Your ultimate one-stop guide to being a rogue tenant. Yes, you heard right. The new Renters' Rights Bill is through its first reading in Parliament. And in this video, I'm going to share with you all the loopholes that you can exploit to be a rogue tenant. But seriously, folks, this bill is on its first reading. So all these loopholes that I'm going to present to you are ones that must be plugged before this becomes law. So let's have a look at the Renters' Rights Bill. Now, first of all, it's been just sort of dropped on the government websites and all of that. And you can see it is a pretty lengthy document. In fact, it's some 226 pages of bill, all presented by the new government. The first thing I'd say about it is the title. The title of this bill is, of course, the Renters' Rights Bill. Now, under the Conservative Party, this was presented as the Renters' Reform Bill. And the title of the bill implied some kind of balance. And I think there was an element of trying to be fair to both sides when the Conservatives are putting forward the Renters' Reform Bill. But the title of this is very clear. It's Renters' Rights. So what's actually in it for the landlord? Is this first draft setting the balance too much in the tenant's favour? Well, let's find out. So I've asked the help of my old friend ChatGPT. What I've done is I've uploaded those 250 pages of the Renters' Rights Bill into ChatGPT and asked ChatGPT a specific question, which is, acting as a rogue tenant who wishes to exploit loopholes to delay paying rent, pay the minimum rent and avoid eviction, suggest legal loopholes in the bill which allow this. So it's a very simple, not that well worded prompt, but it does the job. Let's see what it comes back with after going through the bill. Now, the point of saying all of this is really to say that these are significant loopholes and these need to be addressed before this bill reaches its final assent and becomes law. Some things here are just completely balmy. There is a rent arrears threshold, so you can only evict a tenant if they've got significant rent arrears. Now, in the old days, that used to be 8 weeks worth of rent arrears. If 8 weeks worth of rent arrears built up, then you can seek possession of your property back. But under the new Renters' Rights Bill, you need to have 13 weeks of unpaid rent, and that is considered substantial arrears which you can get possession for. But ChatGPT is coming up with the delay tactic to delay eviction, pay rent just enough to stay below the 13-week threshold. For example, if you accumulate 12 weeks of rent arrears, make a small payment to reset the countdown basically just before the court hearing date, so that basically frustrates the court proceedings. So persistent rent arrears can be a massive problem. This needs to be fixed. Remember, of course, when the Conservatives put the Renters' Reform Bill up, Michael Gove was very insistent that the court system has to be beefed up to be able to process all these tribunals and court hearings and all the rest of it. That has not been done, and these guys are seeking to implement all of this without the court process being able to cope with the increase in court hearings as a result of people exploiting these loopholes. Now, loophole 2 from ChatGPT is challenge rent increases by tribunal. Now, this is an interesting one because tenants have the right to challenge rent increases under Section 7 and 8, which allows them to take a proposed rent increase by the landlord to a tribunal. So ChatGPT is saying that if your landlord tries to increase the rent, you can file a challenge with the tribunal to delay the increase. Even if you have no valid reason to contest the increase, the legal process takes months, allowing you to continue paying the lower rate until the decision is made. Now, this seems to be a ludicrous loophole. Now, when you rent out commercial property, for example, if I rent out a commercial shop, for example, for 10 years, at the end of 5 years, there will be a rent review. Now, if we do the rent review process, that rent review going through tribunals and chartered surveyors and that kind of thing can take months. But whatever the end rent is found to be, the payment of that rent is backdated from the time it was meant to be imposed. So just by engaging a rent review process and delaying it and frustrating it, it doesn't reduce the amount of rent that's payable. That's what happens in the commercial world. And I see no difference in the residential world. I don't understand why, if you propose a rent increase, even if the tribunal finds for you, it will only be valid at the time of the tribunal, from the time of the tribunal, not from the time the rent increase was proposed. This seems to be a very, very silly loophole. Number 3 in the loopholes ChatGPT has identified is the old classic of, basically prolonging the eviction process. In the old days, the bill mandates that specific notice periods and procedures are followed by the landlord, and they need to be followed to the letter. Any deviation from this means that your claim for eviction or repossession will be frustrated. So it's absolutely at the essence to make sure that notices are served correctly and precisely, and attention to detail is followed. And I think this might be harder for landlords who only do it once in a blue moon, but for qualified and experienced property managers or eviction specialists who do this more frequently, they are likely to be more on the ball with making sure they dot the I's and cross the T's. So getting possession back from a landlord's point of view for rent is quite difficult, because as I mentioned before, they only have to make a small payment and be under the 13 weeks threshold, and then they're good to go. So you really have to go in for possession with more than one grounds. And the ground that people sometimes want to rely on is antisocial behaviour. But this is going to be quite difficult. Landlords can seek eviction for antisocial behaviour, but they must provide substantial evidence, and the court will consider various factors, e.g. tenant cooperation, impact on neighbours and the like. So if you're accused of antisocial behaviour, deny the claims, force the landlord to prove their case. So the burden of proof, this is the important thing, which is going to be frustrating. The burden of proof is going to be on the landlord. If they cannot prove it with sufficient evidence, then that claim will be denied. I wanted to tackle some other loopholes which are cause for concern for landlords. Now, of course, with the Renters' Rights Bill, there is no fixed term tenancy anymore. All tenancies are periodic. So what is the minimum amount of time a tenant should be allowed to stay in a property, or can stay in a property? So we've done this prompt here. So I've asked ChatGPT to interrogate the Renters' Rights Bill. How early can a tenant serve notice to vacate the property? Under the Renters' Rights Bill, a tenant can serve notice to vacate a property at any point during their tenancy, but there are specific rules about when the notice can take effect. So what is the minimum term of a tenancy? Does that mean that you can pretty much serve notice to quit on day one of a tenancy? Well, let's try that as a prompt. Can a tenant serve 2 months' notice to vacate a property on day one of the tenancy? Yes. A tenant can legally serve 2 months' notice to vacate a property on day one of the tenancy under the Renters' Rights Bill. Now that is very, very interesting, because if you're now looking for Airbnb to stay in a place for a couple of months, don't bother with Airbnb, don't bother with Booking.com, just go straight over to Rightmove or Zoopla, look at a property on the market, rent it on a long-term basis, and hand your notice in on day one of the tenancy, and then you will only have to pay 2 months' rent and you're clear. Now, surely this cannot be allowed to pass into law. It's plain nonsense. One thing that's always fascinated me is the difference in rights for mortgage lenders to repossess properties when mortgages aren't paid, compared to landlords who want to repossess properties, take back possession of a property if rent is not paid. So let's just see, under the new Renters' Rights Bill, how the interests of mortgage lenders actually compare with landlords in the situation of non-payment of rent. So I put in this prompt: compare a lender's right to repossess the property for non-payment of a buy-to-let mortgage and compare it to the landlord's rights to get possession for non-payment of rent, and to present the results in a table. So here's what ChatGPT says. Okay, the first row is legal interest in the property. Yes, one's a landlord, one's a lender with a first charge. Of course, that's different. Grounds for possession. So a landlord can gain possession after 13 weeks of rent arrears, but of course, if the tenant goes along and pays up a little amount, that clock is reset. That is very, very odd indeed. But with the mortgage lender, there is no provision to keep resetting the clock by just chipping in a little bit, and then you have to wait for 3 months of arrears from that point. It doesn't quite work like that for mortgage lenders. Okay, notice periods. Okay, landlord needs to provide a notice. The mortgage lender provides a default notice and all of that. Obviously, you must go through the court process, but even ChatGPT says that the lender must apply for court, but for a repossession order, but the process is generally faster. Why? Why should a bank's right to get repossession of a property back for non-payment of a mortgage trump a landlord's right for getting a property back for non-payment of rent? In my mind, those interests should be aligned, and the bill should align both parties' interests. Let me know what you think in the comments below. Defences available to tenants and borrowers. Tenants can challenge the eviction on technicalities, invalid notices, or by paying some of the arrears, as I've said, if they fall below the 13-week thresholds. So there are lots of games that tenants can play. Over on the borrower's side, a borrower can ring up their lender and negotiate a repayment plan, or possibly challenge it if there's procedural grounds, which rarely happens with banks, quite frankly. But the defences are more limited. Why should the law allow a tenant to have so many weasel ways to avoid repossession? More rights than someone with a mortgage who's trying to avoid repossession from a bank. That doesn't sound very fair and equitable to me. Again, the tenants have substantial protections, including the right to challenge rent increases, dispute eviction in tribunal or court. It can also talk about repairs and all sorts. But with borrowers, on the other hand, they have fewer protections. Courts may grant possession after a brief grace period if payments are not made. It's pretty much as simple as that. Why can't that be the same as in the Renters' Rights Bill? Again, delay tactics. Tenants can use legal and procedural challenges to delay eviction, pay just enough to avoid substantial rent arrears and all this sort of stuff. Again, delay tactics with mortgages. Well, borrowers can do a little bit of negotiation at the beginning to do a loan payment plan, but you're stuffed really. Your delays you can introduce into the system are far more limited. At the final column, summary according to ChatGPT, landlord's rights weaker as a tenant's protections can delay the process and keep the tenant in the property for longer. But the bank mortgage lender, their rights are stronger as the lender's financial interest typically takes precedence in the court. And there's your conclusion. Mortgage lenders generally have stronger, faster rights to obtain vacant possession as they hold a financial interest, but landlords under the Renters' Rights Bill are stuffed. So what do you think about that? I believe the rights of a landlord should be aligned with the rights of a mortgage lender in terms of getting possession back for your property through non-payment. Listen guys, tell me what you think in the comments below. Also, let me know what you think about the loopholes that I've identified. What do you think about this Renters' Rights Bill? Do you think the balance has gone too far the other way? I believe that there are a lot of things in there that are quite reasonable really, but there are some key areas that are not, and these must be challenged. Otherwise, it will see a lot of landlords exit the market and a loss of many houses and properties in the private rented sector. That's it for this video. See you guys next time. The Baker Street Property Meet is the UK's largest and #1 property investors networking event. The property market is going through monumental change right now, and at Baker Street Property Meet we aim to keep you up to date with the latest tips and tricks and insider tactics to help you keep on top of your property investing game and succeed in these troubled economic times. The Baker Street Property Meet is fundamentally about networking, because it's not what you know, it's who you know. And at Baker Street, we aim to connect you with the people to make your property journey a monumental success. There's no better place to be to further your property investment journey than the Baker Street Property Meet. So make sure you're here, you're connecting with myself and Andrew Roberts, our expert guest speakers, and 300 passionate property people each and every month. See you at the next meet. Get your spot at bakerstreetpropertymeet.com.